Hi, welcome to Chapter 19, the Liability Risk from Principles of Risk Management Insurance course. So in today's class, we're going to talk about liability, legal liability to be specific. So a legal liability is some sort of violation or wrongdoing that is legally considered wrong by a law. So it's going to be it's a violation of a person's legal rights. So the law set up your legal rights as a person, and if someone violates them, that would be a legal liability, and you might be owed a certain amount of damages related to the severity of the violation. So this could include crime, breach of contract, or tort, as far as what we want to say a legal wrong. Now, what is a tort? This is going to be a legal liability that can arise from an act that you intentionally decided to do, or an omission that will cause harm or injury to another person's property. So think of a tort like damaging property, assault, battery, trespassing on someone's land, fraud, slander, copyright infringement. These are all intentional torts. Now, in legal terms, the person who is injured is the plaintiff, and then the person who can be sued for the damages, or the person who created the injury, would be the tortfeasor. So torts can fall into three categories. The intentional, which I was just discussing, the strictly liability, and negligence. So let's talk about the strictly liability. So now, because of the harm that someone can cause to an individual or society, if it's so great, people could be held for the harm or injury done by others through negligence. So if we talk about strict liability or absolute liability, this is going to refer to liability that is imposed regardless of negligence or fault. So some common situations where this could occur would be, now this is, the strict liability isn't going to be a common situation most people are going to be faced with. But if it's some sort of operation, explosive manufacturing of explosives or dangerous chemicals, owning of dangerous wild animals, crop dusting, these are things that would be strictly liability, because they could have the potential to be so harmful that negligence, specific negligence cannot be proven. Okay, so let's just go straight to negligence. So this is the failure to exercise the standard of care that one would expect, or that is detailed by law. So this is really a cornerstone of when we talk about legal liabilities, is how to determine negligence and the laws surrounding negligence. But there's a basic standard of operation or care, and it's going to be different depending on what the wrongful act is. And hopefully the law will base the care that they would consider for a reasonably prudent person. Okay, so let's talk about some laws of negligence. So again, negligence is typically going to be thought of as a failure to exercise the standard level of care that's required by law to protect other people from risk. For example, if you're cooking food, There's a standard level of care of how you handle the food, how you prepare the food, how you store the food. And if you're negligent and people get food poisoning, that's a case of negligence because you didn't perform the basic standards of care for the food. So the standard of care, it's based on what is a reasonable, prudent person would do. So that's just a legal term, and that would have to be further examined and determined by a court or lawyers. But by and large, your actions are going to be compared with the actions of a reasonably prudent person under the same circumstances. So what would a reasonable and prudent person do? And was your behavior less than? Then you could be considered negligence. So if you're below the standard, you're negligent. Now, say for example, if you're an auto mechanic and you're fixing someone's car and you didn't do the right standard or level of care or procedures to fix their brakes, and basically your negligence led to a car accident, you could be liable. But the standard of how we consider standard care is going to be different for each act. So you can see how this can get very complex because there's so many different ways to be negligent, and each way is going to have a different interpretation of what the standard level of care is to not cause any harm. Now, this is why lawyers often will look at the precedents in legal cases to see what was done prior, and that could be a good way of setting up a defense or a court case based on this is what happened today and this is how previous similar cases were ruled. Okay. So let's talk about the proximate cause. It's the relationship between the negligent act and the infliction of damage, which requires an unbroken chain of events. So sort of you want to make what would be thought of as a direct connection between the person harmed and the person's action caused the harm. Okay. So let's talk about a couple other things here. Go back to the previous slide for a second. I want to talk a little bit more about failure to perform a duty. So what we're talking about here is, so this is what we might recall as the second requirement. And so if a person fails to comply with the standard of care to protect others from harm, then your actions would be compared with the actions of a reasonably prudent person in similar circumstances. So basically, if your actions fall short of the standard, that second requirement of failure to perform the duty would be satisfied. Now, if there are damages, so the third requirement basically is that there should be some sort of damages or injury to the. So if someone was clearly negligent, and performed under the level of care, say for example, you're served a rotten piece of food that's probably will cause food poisoning. If you choose not to eat that food and you suffer no damage or harm, and specifically if you haven't yet paid the bill for the food and you refuse to pay for it, you've suffered no financial loss, no harm. There really can't be a lawsuit because there's no damages really. So damage, some sort of injury or some sort of loss of property or by inaction of the transgressor, the tortfeasor, then there could be a claim for compensation. So let's talk about compensation. Basically, simply you get compensated for the damages that you actually incurred, the losses you actually incurred. And the easier it is to define the value of those losses or the value of the damage, the easier it is to be reimbursed for it. Now, we can talk about two categories: special damages. So special damages are awards for losses that can be determined and documented, such as medical expenses, lost earnings from work, or specific property. General damages are going to be awards that are for losses that cannot be specifically measured or itemized in a comparative way, or basically you don't have an invoice for it. There's no comparative product to say this is what was broken, this is today's value. So this would be more like pain and suffering, disfigurement, loss of companionship if a loved one dies. So that's how we break the damages, the compensatory damages, into those two groups, special or general. Now there's an additional that goes outside of monetary value, and that would be punitive damages, which are going to be designed as a deterrent. So if you commit a wrongful act, this punitive damage would be a way to punish you for acts that are so outrageous that besides just compensating those who have been harmed, there's extra damages just for the fact that you need to be punished. Okay, so let's just go to this little graphic. So types of damage, what we were discussing before, we have the compensatory and punitive. Now, so the punitive is to punish the wrongdoer. So that's to be set by a judge or a court or jury. And it could be looked at from similar acts and what the punitive damages were. In some cases, there could be a law already established of what the punitive damages are if you commit such crimes. Such negligence. Now, compensatory damages that we're talking about before, here lists some examples that similar to what I was talking about. So just a little graph of damages. Okay, so let's look at contributory negligence law. So now, as far as defense against negligence, there's a few different items here. Contributory negligence, comparative negligence, less clear chance rule, and assumption of risk would be the ones that we're going to talk about. So first up, contributory negligence. So this is going to be basically a law, and it means that if the injured person conduct falls below the standard of care required for his or her own protection, then such conduct contributed to the injury. Say for example, you're working with dangerous chemicals, and there's a clear warning or a clear standard that you wear protective eyewear when working with these chemicals, and then these chemicals damage your eyes. You might fall into the category where you did not have the required protection or standard level of care. So because of this, you might not be able to collect any damages because it's partly your fault. So if you contribute in any way to your own injury, you can't collect damages. Another example could be the person that puts water on the floor or ice on the floor and then comes back a few minutes later and slips on it. So if you're in a restaurant and you put water or ice on the floor and then you come back and slip on it, whether or not you did it on purpose or by accident, the standard level of care is if that you're in a restaurant and you spill ice or water, you alert someone in the restaurant to come clean it up, or you clean it up yourself. Otherwise, if you fall in your own mess, under this law, you would not be able to sue for damages. So that makes sense, right? Now, let's move on to comparative negligence law. So now, because the contributory law can be thought of as could be a little harsh in some cases, where maybe it was only a little bit your fault and mostly the company's fault or another person's fault, still you get nothing, you can see how that might not work out in a lot of cases. So states have modified it to enact comparative negligence, to look at how much of it is your fault, how much of it is the other person's fault. So it allows an injured person to recover damages even though they in some way contributed to the injury. So under this law, the plaintiff, who's always the injured person, and the defendant, which would be the person who caused the negligence or is accused of negligence, contribute to the plaintiff's injury, then the financial burden of the injury is shared by both parties. So this comparative negligence, it seems a little bit more fair because, you're going to share the blame. And this is something we'll talk about in the auto insurance chapter when we look at a lot of auto accidents are going to be looked at as a comparative negligence, where some percentage of the accident's your fault, some percentage is their fault, But the states, this law is not uniform across the country. There are different variants of it, which could be the pure rule is one variant of it. So under the pure rule, you can collect damages for your injury even if you are negligent. So your award is reduced proportionately depending on the percentage of your fault. So if you're 75% of the fault, you can only collect for 25% of the damages. Some states follow the 50% rule, which is you cannot recover if you are 50% or more at fault. So if it's determined the fault is 50% or more your fault, so 60% of the accident is contributed to you, you can't collect anything. Now, there's another variant of this called the 51% law, which a number of states, maybe 20 or so, follow this, and you cannot recover if you are 51% or more at fault. However, if you are 50% or less at fault, the damages will be reduced proportionally. So that's sort of just very similar to the 50% rule, but it's at 51%. Now, let's move over to the clear last chance rule, which is third of the four defenses against negligence. So this is kind of a modification of that contributory negligence that I was talking about earlier. And we call this the last clear chance rule, which is basically going to say the plaintiff who is, endangered by his or her own negligence can still recover damages from the defendant if the defendant has, a last chance to avoid the accident. So for example, say you're driving in a car and you see another car up ahead, and you can easily swerve out of the way to miss hitting this car, but instead you hit the car. So that would say that, you're going to be at fault, or partly at fault, because you had a chance to avoid it. Say for example, somebody has a very expensive piano in the road, and you're driving and you hit the piano rather than swerving around it. So since you had a clear chance to avoid it, and you failed to do so, the person who owns the piano can actually recover damages from you. Okay. The assumption of risk doctrine. So this is the last in the defense of negligence. And here we're going to talk about a defense that can be used to defeat a claim for damages. So under this particular law, a person who understands and recognizes and is aware of the danger in a particular activity cannot recover damages in the event of an injury. So in effect, you're assuming risk. Your knowingly assumption of risk bars you from collecting on the damages you suffer if another person's negligence causes injury. So if, say for example, if you're playing paintball and you get injured during paintball by your friend injures you, or if you're playing football, and the person is much stronger and bigger than you, and he neglects to really reduce the level of force, and you're injured, you can assume that as far as if you were the bigger guy that injured the smaller guy, you could say that there was an assumption of risk if you're going to play tackle football that, you could get hurt. So you're going into the game assuming you can get hurt, or if you go into paintball, you're assuming you could get injured as well. So this assumption of risk means that, if you're going to do something risky, that you're inherently aware of that this is a risky action and you get hurt, that's going to affect the possibility of collecting damages for that. Okay. We're talking about imputed negligence. This is a certain type of condition where the negligence of one person can be attributed to another person. So sort of like a transference of negligence. And there's a couple different scenarios here, and we could talk about the vicarious liability law. So this is a law. So motorist negligence is imputed by the owner, the vehicle's owner. So what does this mean? So say you're driving, and you're driving for your boss. You're driving a company vehicle for your boss, and you have an accident. Who's liable? Well, your boss in his company could be held liable because you're driving as an agent for the owner. So the owner could be legally liable. It could be held legally liable if you injure someone while driving your owner's car for business. Or it could be as simple as if you borrow your friend's car to do a favor for your friend to pick their wife up at the airport, and you wind up having an accident, your friend can be held liable as well as you. So because it's his car, his errand, and you're doing the favor. Now, under the family proposed doctrine, this is another imputed negligence. So the owner of an auto can be held liable for negligent acts committed by a family member. So this is important if you have a family, and maybe you all have different insurance policies or one insurance policy. So if say you take your mom or dad's car out for a spin, and you negligently damage somebody or their property, your mother and father could be sued and held liable because it's their car, you're in their family, and you represent them. So legally, if your kids take your car, or if you take your parents' car and the other side of it, those liability will be imputed, connected the parents to the child. And that's why, you should be under your own insurance, would help clarify who's liable, and under your own registered car. And that's why it's never a good idea to lend your registered car, that you have your car that's registered to you and you have insurance in the car, to somebody else, because you could be held liable. Now, as another example as well, is say you're in a business with a few partners. So one of the partners is negligent. You could be held responsible as well. So both partners could be sued for damages. Now this, there's a dram shop law, which basically, if you're the one that's selling a product and someone else is hurt by this product, they might be able to sue the store for damages. So if the store is selling, a classic example is liquor, alcohol, or a bar is selling liquor, alcohol, and you wound up, creating damage or a situation liability, that shop could be held accountable as well. And the classic case, if it's a bartender clearly sees you drunk but still continues to sell you alcohol, you could be liable. Or if you're a liquor store and someone comes in drunk to buy more alcohol and you sell it to them, these are situations that could occur. Res lopiace loquitur is another doctrine where it says the thing speaks for itself as a translation. Now, under this doctrine, the very act that the injury or damage occurred establishes a presumption that negligence is on behalf of the defendant. And it's then up to the defendant to refute the presumption of negligence. So, this act or this action or injury normally would have occurred if the defendant had not been negligent. Examples could be, a dentist extracting the wrong tooth, an operation being performed on the wrong person, maybe the wrong organ is removed from a body, maybe a surgical knife is left inside the body, although I don't think that's ever happened. But it's it's an event that should normally not occur. Even with the even in the absence of negligence, this should not occur. Now, so the requirements for this to be met, of course, is the event normally does not occur. It's not a common event. The defendant has exclusive control over the event that caused the accident, and the injured party has not contributed to the accident in any way. So it's just basically saying this is very obvious that this is negligence. It's just what occurred speaks for itself. It's just you describe the situation, and it's just outrageous negligence. So it just really means the negligence was very obvious, and it's almost irrefutable. Okay, so let's look at some specific applications of the law of negligence. So let's talk about the trespasser. So this is going to be the person who comes on to another person's property without the owner's permission. So basically, you never asked for this person to come onto your property. So your duty would be a duty of slight care. So, which basically means you don't really have any obligation to keep the land, in a reasonably safe condition. So if the trespasser gets hurt, basically walks onto your land and he trips over a stick or a stone and breaks his ankle, that's not your fault. However, if you specifically set up traps to injure a trespasser, then that could be what we call the duty of slight care. So, say for example, I call this the Home Alone situation. If you're going to set up traps for a trespasser, paint cans that fall on your head, or ice on the staircase, or a heated doorknob, these are things that you could be held liable for. But if the person, if you take the minimal amount of care of your property, you're not intentionally trying to hurt a trespasser, then you'll be fine. But if, so that's one example, pretty common, pretty obvious. And especially, if you have a trespasser and you put up warning signs. So if you have a dog that might bite and he's contained within your yard or your house, and you put up a warning, a caution, this dog bites, or beware of dog, that's going to help you out in a lawsuit. If the person who trespassed on your property was bitten, you could say, I clearly had signs stating that, the dog is dangerous. Now, this is not going to be, nothing's 100% surefire. There still could be, it depends on the whole case and how the judge views it, and, a couple of different things here. Okay, so a licensee is a person who enters the premise on the occupant's express or implied permission. So you're basically licensing the property for them to come onto it. And then as a property owner, you have to warn them of any unsafe conditions. For example, a loose floorboard, a rusty fence, or there's dangerous lawn chemicals on the ground, so don't have your children play there. These are just common sense things that you should tell to someone who you're going to license your property to, which you're basically, you might invite someone over to stay for a couple nights, whether you charge them or, they're going to use your property. Now, an invitee is the person you're inviting onto the premises for benefit of the occupant. So this is going to be, more of a case where maybe you're charging someone rent, or charging someone like an Airbnb fee. It could also be, if you're a customer in a store, or, it can even refer to a mail carrier or a garbage collector who's going to come on your presence to do you, which is a benefit to you. You as the occupant of that premises, you have the obligation to inspect the premises and eliminate any dangerous conditions. So, especially for a mailman. So if a mailman's or a mail person is gonna come onto your property to say you have a type of mailbox that's attached to your house, it's your responsibility to provide a clear and safe walkway. So if it snows, you need to clear out the snow or the ice. Otherwise you could be held liable if the person hurts himself coming onto your property to deliver the mail. Okay. And this chapter, as we're going through it, is an important chapter for the future chapters coming up when we're talking about home and auto insurance. So this is just laying the groundwork of liability that's going to be covered more specifically for auto and home in the upcoming chapters. Okay. Attractive nuisance. So this is going to be, a hazardous condition that can injure a child. So for example, if your house has some sort of feature that is capable of injuring a child, such as a rusty playset that's falling apart, a pool that's not properly fenced in, a ladder or something a child could use to get into more harm, this is a liability to you if the children injured who come onto the property being attracted to some sort of feature, article, or piece of equipment. For example, maybe you have a lawnmower or snowblower or something that they could, left on that they can hurt themselves with. And the idea is that children may not be able to recognize the inherent danger of certain objects. Maybe you leave an axe outside or a chainsaw. These could be of interest to children, and they could utilize, and they can severely hurt themselves. So you, as the person in the property, you have to keep the property safe in the conditions of care at a certain level. And this is pretty common sense, we would say. Okay. Let's talk about owning and operators of automobiles. And we'll cover more of this in the auto insurance chapter. But basically here, if you own a car and you drive the car in a careless or irresponsible manner and somebody gets hurt, you're going to be liable for the damage or injury that the other person is going to sustain. So as the operator of the vehicle, the courts have to decide, what type of negligence, and a clear chance rule, no fault auto insurance, more of something we're going to go over in the next chapter. So there's a lot of different factors at play here, but basically, if you don't have a certain level of respect and care for the automobile or how you conduct it as a driver, this can put you at, a liability situation. Now, in all states, an owner can be liable for an operator's negligence if there's an agency relationship exists. So if your friend drives your car on an errand or business errand and someone becomes injured, you can be held liable. And as we discussed earlier under the family doctrine, the owner of an automobile can be held liable for negligence when operated by an immediate family member. So this is why if you have a car, don't lend it out to your friends or your brother or your sister. If it's your car, you have the title to it, you insure the car, lending it out to somebody could make you liable. So be careful of that. Okay, so, and also here we're talking about charitable institutions are no longer immune from lawsuits, especially respect for commercial activities. So charitable institutions used to have sort of an exclusion to that, but now they are going to be liable. Let's look at specific applications of the law of negligence. So, when we're talking about government entities, they can be sued in almost every aspect of government activity. Now, there's a doctrine of sovereign immunity, which is basically in the past meant that the government, which is often represented by a king or queen, can do no wrong. And if it can do no wrong, it can't be sued. Now, this has been modified over time, by both statutory statutory law and court decisions. So governments can be held liable if it's negligence for performing proprietary functions. So things that governments ordinarily do such as maybe operating water or electric plants or transportation, things of that nature. So say for example, the government has a baseball field, and on the baseball field there could be some benches or some seating, and someone gets a very nasty piece of wood, gets jarred into their leg because they're sitting on a untreated wooden bench, and they need to go to the hospital for stitches. The government can be liable for not keeping those benches up to a certain code. So today governments get sued all the time. Now there are certain immunities for governmental functions that they're just not as strong as they used to be. So in most cases, governments do get some special protections, but in some cases, they don't hold up depending on how the lawsuit, for example, you might be an employee of the state of New York, and then you fall and hurt yourself on the state property. It's questionable whether or not you can sue the state for that. So we really have to look at the specific case and circumstances, and so each lawsuit would be held kind of differently on the outcomes. So let's go to respondent superior. Now, so an employer can be held liable for the negligent acts of its employees while they're acting on the employer's behalf. So basically, some of you work for companies, and if you're working for a company and you do something that hurts a customer, and you're an employee and you're acting within the scope of your job, you most likely wouldn't be sued because you don't have much money to go right for the corporation or the owner. So since you're representing the owner or the corporation in the work you're doing, and you're doing the work as detailed by them, especially if it was, I can give you an example. I'll probably use this example in other cases here, but okay. So there is a often misunderstood story about a woman who went through a drive-through at McDonald's and was burned by hot coffee she spilled in her lap, and sued McDonald's and won millions of dollars. So now, the employee who's responsible for this liability? Was it the person who made the coffee, the person who served the coffee to the woman, or is it the woman's own fault for spilling it in her lap? So most people would feel it's the woman's own fault for spilling it in her lap, and that the lawsuit was frivolous. But if you look at the details of the lawsuit, she won because the temperature at McDonald's kept their coffee, as documented by a training manual, was far hotter than it should ever really be. So it was considered an very unsafe level of temperature for the coffee. Now, the reason McDonald's sought to make their coffee so scaldingly hot was so it would be appropriately hot when it was, by the time you got it home, if you're coming through the drive-thru. But 10 minutes later, it would be perfect. So to try and attempt to get the coffee the perfect temperature when most likely the customer would drink it, it was way, way too hot. Now, since the coffee was at such an extremely violent temperature, and the woman who spilt the coffee in her lap suffered third-degree burns and a hospital stay and skin grafts, now you can see why she had a good case to be compensated for damages. Now, the damages were in the multiple millions in the beginning, but that later was appealed, and the damages came in at a much lower level. But there's an example where an employee is following the instructions of how to make the coffee and how to serve the coffee within the scope of their employment, and the negligent act occurred, so McDonald's was sued for that. Now, also, parents beware, you can be liable for the action of your children. So if your children, use a dangerous weapon to hurt somebody, like a knife or a gun, if the child is acting as an agent for the parents, definitely the parents are liable. So this is something that parents should be aware of. Now, especially if children reach what they call an age or reason, so they're responsible for their own actions on the most part. However, there are some exceptions to this. So if the child is going to use a weapon like a gun or a knife and injure someone, for example, say you have a 10-year-old child that's permitted to play with a loaded revolver and someone is injured or killed, the parent can be held responsible, as they should, right? Or if the child is acting under a parent's directions. If a parent gives a child a gun and says, go shoot somebody, of course the parent's going to be liable for that. So there is a special connection between parents and children that can hold the parents liable in certain circumstances. Say there's a family car and a minor takes the car. Maybe he takes the car without his parents' knowledge, but the parents can still be held liable under the family proposed doctrine that we talked about earlier. Okay, so let's move on to animals. So if we all know that show on Netflix about the guy who had the tigers. I forgot the name of it. You probably know the name of it. And, he had these wild animals. So if someone gets injured from an animal that's not domesticated, like a wild cat, you can obviously see that the owner of the exotic pet is going to be strictly liable, if that pet escapes and hurts somebody. So say you had a bear or, a coyote, and it's your animal and they escape from a zoo, that personal private zoo, or you're going to be held liable for that. Now, what about if you have just an ordinary cat or a dog? So under what they call a bite law or dog bite law, the owner is automatically liable for injuries caused by the dog, and they have this one bite rule, which applies that the injured person must prove that the owner knew the dog was dangerous. So some jurisdictions determine whether the dog owner is liable for injuries caused by the dog by applying standards of negligence that we kind of discussed earlier. So the bottom line is, if you have a dog or a cat and there's a gray area here, and they're not vicious or they never hurt anybody, they're not dangerous, and they do wind up biting somebody, say you take your dog out for a walk or to a dog park, that's one situation that could be looked at carefully to decide negligence. Now, in the other case, if you have a dog that's knowingly violent, has hurt people in the past, or you've suffered injuries from, and they wound up injuring someone at a later date, you're definitely going to be liable for that. So be careful. I mean, similar things can happen with other animals, birds and dogs and snakes and spiders and stuff, but I think the best thing is to keep your animals away from other people. Okay, so let's talk about the current tort liability problems. So we're going to talk about the rising liability costs for litigation, the inefficiency in compensating the victims, the uncertainty of the outcomes, the high jury awards, and the delays in settling lawsuits. So first, let's look at the costs over time. So some factors that explain why the tort costs have gotten to be out of control is that judges and juries don't always understand the value of the dollar in determining the damages to be awarded. Sometimes they make egregious mistakes. Aggressive or creative litigation strategies that prolong the litigation or increase the cost of the litigation, or wound up creating awards much higher than they should be. Rising medical costs, because medical costs are so inflated and constantly going up, it's naturally going to make the amount of awards in liability increase as well. Abuses of class action lawsuits. Many lawyers allegedly could be thought of as greedy and looking and chasing class action lawsuits. So if there is a class action lawsuit, aggressively trying to find as many participants as possible, even creating situations where they're developing these class action lawsuits strictly for the purpose of the legal team making money. States striking down portions of tort reform. So tort reform is when laws are created to try to make tort liability cases more fair and more just. And this typically lowers the amount of cases that can be brought to court because it clears up the circumstances of which is negligent or liable. And when these reforms are cut down, then it's going to bog down the legal system with more cases and more costs. An increase in lawsuits against company officials, as it's become clear that company officials can be held liable for certain situations. More lawsuits, because they have deep pockets and lots of money, more lawsuits have naturally been chasing these company officers. And that relates to deep pocket syndrome, where if there's a liability, they're going to go after the party with the biggest amount of money. So not the employee that makes minimum wage, but the company he works for. Not the driver of the automobile, but their auto insurance or the manufacturer of the car. And also the media blowing up or publicizing cases that could encourage more people to file suits that are unnecessary. So if we look at overall as a percentage of GDP, we can see in the 1950s it went to just almost 0.5% of GDP to almost 2% of GDP as far as the cost of tort. And this is in 2006. Let's move to the next slide where we get to 2010 is a little bit closer, not as up to date as we'd like it, but $264 billion out of a $14 trillion economy is the 2%. So that's a lot of money related to tort costs of the economy. So it's a big, and that's why, these legal lawsuits, and on one hand, it's good because we are keeping the responsible parties in check so they don't continue to hurt people or make dangerous products or create dangerous situations. So there's an overall positive effect to society by being able to sue manufacturers, companies, doctors, individuals who may have inherently created very dangerous situations through the neglect, and they should, and this theoretically will help correct or prevent that behavior. So there's a lot of benefits to society. Clearly, one of the negative societies is the extreme amount of cost. And this cost is going to be absorbed into the cost you pay for your goods and services. Okay. And this is the average personal injury award. And you can see that if we look at, here we have 2006 to 2015. You can see how they've gone up for auto, premises, medical, product liabilities. Things are ever increasing in the cost of these situations. Now, if we talk about tort reform, this is a way of trying to make the tort system more fair. So in some cases, capping the total amount of non-economic damages for pain and suffering. So making because pain and suffering, they could award millions for that. So if they had some sort of common sense cap on the maximum award for certain situations, reinstating the state-of-the-art defense for product liability cases. Basically what we're talking about here is if a product was made in 1970 and your child gets injured with it today, if the product's considered to be safe by 1970 standards, then that's going to be defense. You can't hold a product from 1970 up until today's standards of level. Because things change over time. And this always brings to mind that famous Saturday Night Live skit where Dan Aykroyd goes on a talk show and he's talking about the new toys of his company. And one of the toys is a bag of glass, which in no time was considered a state-of-the-art safe product. But it's just a hilarious skit, or it brings me to mind when I think about this case. Restricting punitive damage awards. So another restriction placed on the amount someone can be punitively liable for. Modifying the collateral source rule. So this is so under this rule, a defendant cannot introduce any evidence that shows the injured party has received compensation from other correlated sources. So, as an example, say you're a delivery driver, who is injured in a rear end collision, and so you may be able to collect medical expenses from the negligent driver. However, job-related medical expenses are also covered under the workman's comp law. So therefore, the injured driver might try to double dip and receive a total amount that exceeds the medical bills. So this collateral source rule would be modified so that the recovery from other sources could be considered in determining the damages to another party. So this is a way of saying, don't double dip in, say you're in a situation due to someone's negligence, you lose ability to work temporarily. But you're being compensated by your employer who's paying you anyway, and they would look at that as far as before awarding damages for lost salary. Okay, joint and several liability rule. This is going to be so several people might be responsible for an injury, but the defendant who is only slightly responsible may be required to pay the full amount of damage. So if this happens to one defendant, they always going to look for the deep pockets to get the money, rather than people who have no assets. Under the reform, they want to modify this joint and several liability rule that, in a way that would prohibit application of the joint and, several liability rule for non-economic damages, such as pain and suffering. So trying to limit the amount of reward by how many people they're going to go after. Alternate dispute resolution, or ADR, is a technique to resolve legal disputes using arbitration or mediation. So this is commonly used for say in marriage situations, but that's not legal liability. But in a legal liability situation or tort situation, instead of bogging up the courts and lawyers in the expensive process of a lawsuit, both parties get together and agree to an arbitrator to hear both sides and then declare a resolution. Rather than, this is much lower cost and effective way, and specifically saves a lot of state money rather than having so many people involved at high costs. Okay, so let's go to a specific area, medical malpractice. So, and the basis of this is your doctor should not do something negligent that's going to harm you by a specific act or omission. For example, a specific act would be, performing a procedure on you that hurts you in some way, or they don't tell you about another a potential remedy that is admitted by the physician that results in some sort of harm or injury to you. Now, so this is in place, which is normally a good thing to have medical malpractice. So if there's a bad doctor out there that's hurting people, they should be sued or driven out of business. So that's a good thing. So it helps keep doctors will be more cautious. Doctors would be more responsible to their patients. However, like a lot of the tort liabilities, the lawsuits have created a huge burden on the industry, where many of the lawsuits are frivolous, or many of the lawsuits are people being awarded damages where perhaps they shouldn't be awarded. So, an injured patient has to show that the doctor deviated from what's the general standard of practice, or if the doctor made a medical error, or if a hospital made an error. These are things that can lead to these malpractice suits. So here are some reasons why patients would sue the physician. Now, in the past, there's a much stronger relationship between a patient and a doctor, that they had a lot more trust in their doctor and a better, communication, and they'd be less likely to sue. In today's medical world, you're often not seeing the same doctor twice. Or if you're seeing a doctor, it's for a very short period of time. There's no relationship build up. There's no trust, which may lead you more likely to litigate than to discuss it with your doctor. Now, I know I had a dentist for, I would say, over 30 years that I completely trusted and never second guessed. And he was just a wonderful, excellent dentist. that when I eventually had to go to a new dentist, I could feel myself being much more suspicious of their actions or what they're doing, with the feeling that some dentists want to drum up extra business and may prescribe extra procedures that are not needed or services. So I was just suspicious, and that's the type of atmosphere that could lead for more lawsuits. Now, and of course, people are more litigious than in the past. In today's society, the concept of suing someone or the threat of suing someone is in the forefront of most people's brains. But in the past, people were not so enlightened about suing other people, or not so, anxious to do it. So in today's society, some people see a lawsuit as a payout or an easy way to get rich. And that impression is what creates a lot of lawsuits, especially medical. Medical lawsuits have a tendency to pay out a great deal. And now in today's world, physicians will testify against each other for money in malpractice cases. So experts they don't really protect each other anymore. Which is, I guess, a good thing that you would want. That I don't think that's necessarily a bad thing, but it winds up leading to a lot more cases being lost by the doctors. The media plays on people's fears and often will, talk about lawsuits or medical malpractice, and so making people more aware, often sometimes more afraid or suspicious, which can lead to more lawsuits. Now, attorneys specifically, building back practices around medical malpractice and having higher fees, more advertising. Sometimes we call these ambulance chasers. So the industry of lawyers specifically to deal with personal injury. And you may have seen some of these commercials on TV. And then the overall growing resentment for greedy, large for-profit healthcare companies, the fact that people are paying so much for healthcare and healthcare insurance, and these companies perceived as greedy, helps people feel justified in suing them. So these are all reasons why these lawsuits increase. Now, so one of the problems one of the problems in all these medical malpractice lawsuits is the money that doctors have to pay to have medical malpractice insurance to cover them in case of a lawsuit is inflating the cost of medical care. So because hospitals and doctors and physician groups and they have to pay so much for insurance against the possibility of malpractice lawsuits, that raises the prices for everybody who has to cover the cost of those awarded. So if someone wins a $10 million lawsuit, that cost has to be spread out on new charges to new patients in the future. So methods to reduce the medical malpractice would include not charging for never events. So if a never event occurs, there should be no charge to the patient for that. Laws allowing physicians to apologize without admission of blame. So basically, the doctor can apologize without it counting as admission to use against them. Because in some cases, a lawsuit can be dropped with just a admission of guilt and a apology from the doctor. In cases where people are not severely hurt or injured. A prompt disclosure of medical errors. So if a medical error occurs, it's not covered up, it's immediately exposed, and the patient is warned and corrected, is going to reduce lawsuits. More corrective or remedy action against problem physicians. So physicians are known to have a problem or create problems, that they should be more closely retrained, reprimanded, or fired. And a more emphasis on risk management principles. So hospitals and doctors do have some of this risk management principles, but sometimes, even though this could be could reduce malpractice costs, sometimes it can increase the cost of doing business. So even though certain checklists or certain things that hospitals and physicians have to do will cover them in most malpractice cases, it also can sometimes result in many unnecessary tests or unnecessary procedures that the patient most likely does not need, but are done anyway to prevent malpractice suits. So that's sort of like doctoring to prevent malpractice, which you really should doctor to what's best for the patient. Now, another situation here is the current tort liability on the tort liability problems is class action lawsuits. So what class action means is that it's a large group of people that's going to sue for damages. So a lawyer or a law firm is going to represent a group of people who may be injured due to something such as, say, asbestos in a product, or a dangerous chemical in a food or drug or drug side effect that was known but not revealed, or even the case that some auto manufacturers like Ford and GM produced cars that they knew would injure people but continued to produce them because it was cheaper than fixing them. This could be the grounds of a very legitimate class action lawsuit. Also, commonly, there could be class action lawsuits for stock-related issues. So if there's a public company and there's a mismanagement, or a company officials don't disclose something shareholders should know, or lying or fraudulent, that could develop in a class action lawsuit where shareholders can sue the company. So for example, you might have a company like Luckin Coffee that falsified revenues or profits, and then the stock was legitimately a higher price because of this, and once it was revealed, the stock crashed. So you could have, anytime a stock goes down by a huge percentage point, they're going to look to form a class action lawsuit against the company to see if there's any wrongdoing there. But all these class action lawsuits propagate, the costs of tort liabilities and increase the payouts. In some cases, legitimately; in some cases, not legitimately. So people say that class action lawsuits, make something more efficient than each person individually suing. But opponents would say that the lawsuits really benefit the lawyers more than the people who are being represented, because the lawyers wind up taking a huge percentage of the payout. Okay, so let's, some other more current topical issues is, what about cyber liability? The risk that someone's going to gain access to your data. And this has happened to all of us, where, schools have lost, or data has been breached in schools' information, including social security numbers and bank accounts and credit cards, and not just schools, businesses, primarily businesses, have been attacked and personal information has been exposed. Hospitals and doctors have been cyber attacked and personal information has been exposed. So who's liable if your information gets out there? So I guess, the risk of, did the company do what was proper safeguards to protect your information? So this is a bigger situation occurring, where there's this cyber liability, where companies may be negligent in the way they manage or hold your data. Now, public entities, may be sued for wrongful, this is talking about governments. These public entities could be sued for wrongful convictions, civil rights abuse, motor vehicle accidents, sexual abuse or harassment by a public employee, or police shootings. So this is another problem in the tort law, how to deal with, public servants. Now, as the current topical situations where, especially police are under a much stronger microscope by their actions and what they're doing. And so a lot of this is resulting in police officers wearing body cameras. So events can be more accurately recorded. So, which is good for cops who follow procedures and do things correctly. They'll be easily exonerated from liability cases, but may wind up creating more payouts if the police force is improperly trained and improperly conducting themselves. Finally, organizations using unmanned aircraft or drones, could they be liable for damages caused by the drone or improper use? So say, for example, what if, an organization like Amazon is using drones to deliver packages, which they're testing, and where the packages gets delivered to your front door by a drone. What happens if that drone crashes into somebody walking, or into a car, or into a house? And so these are new things that are always coming up in the law that's going to be legal liabilities are going to have to look at, examine, decide what to do. Okay, so that's the end of this chapter. This chapter is only going to have a part 1 of 1. It's a smaller chapter. Next couple chapters, we're going to move into applying what we learn in liabilities into situations like home insurance and car insurance. Okay, I'll talk to you soon. I hope you enjoyed this lecture.